Hey, so thank you for joining the Women in Innovation Introduction to Intellectual Property for Entrepreneurs and Startups webinar today. My name is Siobhan Smith. I lead on the Women in Innovation programme within the Knowledge Transfer Network. Before we begin, I just want to say a few quick announcements. So as you may have noticed when you joined, that you'll be muted throughout today's webinar, but there will be an opportunity to ask questions following the session. Please type them into the Q&A box and we'll be reading them out from the Q&A box at the end. If you've got any technical problems or you'd like to network with other delegates, please use the chat box to do so. This webinar is being recorded and the session materials as well as the recording will be sent out to all delegates within a few days following the webinar. So I'm now going to introduce you to our hosts for today. So Dr. Hayleigh Bosher is the Intellectual Property Law Lecturer and Legal Consultant. She is an internationally published legal academic, speaker and legal consultant specialising in intellectual property, media and entertainment law. She's a lecturer in intellectual property law at Brunel University in London, blogger for the specialist IP blog IP Cat. I hope I'm saying that rightly, Deputy Editor of the European Trademark Report and founder of World IP Women Network. She holds a PhD in copyright law from Bournemouth University under the Vice Chancellor's Scholarship Award. And we're also joined by Professor Robert Holdway. Rob is a Professor Associate from Brunel University in London, the College of Engineering, Design and Physical Sciences and Innovation Director. Co-Innovate an innovation support program for London-based SMEs, entrepreneurs and startups to achieve business growth through collaboration with Brunel's world-class academic expertise, knowledge assets and facilities. Rob is also a founder and director of award-winning environmental and innovation consultancy Giraffe Innovation Limited. He's an award-winning designer with over 24 years professional experience as an industrial designer, innovation consultant and sustainability professional, working on new product development, eco-design and life cycle assessment. He started his career at Philips Corporate Design and worked on global innovation management for Unilever Research. He's worked with numerous businesses, including Red Bull Advanced Technologies, GlaxoSmithKline, Dell, Waitrose, BT, Unilever and Sky, as well as many small companies. So I'm going to pass you over to Rob now, who will begin the webinar for us today.
Hello, can you hear me? Can you nod, Hayleigh, if you can hear me? Brilliant, thumbs up. Well, welcome everyone, and thanks for the your time today. And I'm delighted to be part of this KTN presentation. I'm going to set the context really about the role of IP in the innovation journey. And I could cover this in not much longer time, so I'll try not to make it too long for you. And hopefully you've got some good questions that will prompt some debate and some further follow-up. So I am representing Brunel University London today. Lucky also we have my colleague Hayleigh, as you heard in the introduction. So I'm going to cover the broad context of innovation, how it hopefully relates to your business. You're going to be a diffuse audience, so hopefully that each part will connect with you and what your business needs. And leading on to this, the problem with innovation is it means so many different things to so many different people. And I quite like this Indian parable, which talks about the blind men touching the elephant. And of course, your paradigm, your model of the world is determined by your own perspective. And particularly for smaller companies who are trying to develop a new product or service and to innovate, it's very hard to have all these multiple roles. So one of the good things about the Co-Innovate program and working with academics and universities and other businesses and the KTN and Innovate UK, etc., is you can draw on this pool of experiences. The dilemma, of course, is what you're trying to do is to build a consensus and an upfront knowledge. And the thing about IP, it's often forgotten until the end. And in my world also, a bit like sustainability is not necessarily built in from the beginning. So if there's any message I'd really like to convey is IP is a great source of innovation potential, seeking ideas, seeing what precedents there are and state of art that already exists. And it's really important you bring that in from the outset in the development process. Two reasons. One, for the opportunity it might afford you, Secondly, you might be infringing someone else's intellectual property. So you could be a very expensive mistake to make if you don't consult and consider IP from the outset. The other thing is, most projects fail, and I'll come on to this. There seems to be a sort of view, without highlighting the risks. Innovation is extremely risky, and the worst thing you can be doing is to do well the things you shouldn't be doing in the first place. So making sure that IP is part of all the other things that you do in innovation is critical. Understanding the incipient demand, the market trends, the customer personas, all the aspects of the functionality, the technology. IP has to be part of the mix. This is a story from Chris Knight, and it's a story about the Lotus bike, and it's quite a nice insight, really. What's your core capability within your business, and also what's the value proposition? What real value are you offering to the customer? What problem are you solving, and in what context? And Lotus were an engineering consultancy, and they effectively just got carried away and designed this very nice bike that won a gold medal. That sort of saved them, but they nearly went bust as a result, according to Chris, the then CEO. They got carried away and distracted. They did the wrong thing well, very well. They got a gold medal. But the only thing that really saved them also was they learned a lot about carbon fiber, and they were able to embed that into their business. But they were an engineering consultancy, and they said upon reflection, and they made a few cards, upon reflection, they wouldn't have got involved in this. So you don't want to be doing the wrong thing well. I guess doing the wrong thing badly is even worse, but hopefully we're trying to avoid that. So innovation means finding new ways to do new things as well as new ways to do old things. And there's a lot, Hayleigh knows a lot about this, of course, but there's a lot about cumulative creativity and building on what's gone before. And of course, if you are building on a derivative of what's gone before, it's important to be aware of the precedents and state of art of the IP that's associated with it. The other thing about innovation, you haven't innovated unless you've made a commercial return, or you've massively increased the efficacy of your business, or there's a social penetration to what you're doing in terms of, say, for instance, charity work. But it is a successful commercialization of ideas. It's not, and particularly going forward under this crisis, it's important to think about the commercialization in terms of making profit and a return that you can reinvest. And I see IP as part of that investment. And when I started my business, one of the first things I invested in was getting a community trademark for giraffe innovation and for giraffe in the classification, so that I could protect that, trade on that, and hopefully build a brand around it. The other thing is, I thought I couldn't resist, sorry, but 72% of product innovations flop. There's a museum of failure, which you should have a look at. It's great. All these products and endeavor of human brains that are complete flops. But profitability is at risk. Most companies fail to successfully position the products in the market. Having the right technology, if you're very technically focused, that's great. But you have to understand what the softer side is and how the market might reflect. This is one of his failures, one of his ridiculous ideas. I think he's come up with a few more recently, but anyway, maybe less life-threatening if you play this than some of his other suggestions. This is a great game if you don't have many friends. So I think it's one of your favourite games, Hayleigh. But anyway, there we go. Right. So most projects fail, and if you look at like Harvard Business Review and AG Lafley, Procter & Gamble, probably about the failure rate or success rate is about 3.5 out of 10. So if you look at, say, there's 10 businesses in the room, probably maybe only 4 of what they're developing at that one time might become a successfully commercial development. And of course, a lot of them don't find out when they're successful or not until they've launched, and that's a very expensive way of doing it. So again, if you're not thinking about IP and protecting or a potential of infringing from an early stage, there's a very high chance that you're less likely to succeed. And if you do succeed, you haven't protected one of your key assets within the business. I think you're getting the general theme of what I'm saying. So a lot of the case studies and the narrative is, oh, you must innovate. Well, innovation is extremely risky, but the ultimate risk is not innovating in the first place. But it's important to mitigate that risk and try and minimize it as well. And you can see a statistic there that actually IP will facilitate greater collaboration. You're more likely to protect something that will lead to exporting, and also there's evidence to attract more qualified staff and investors, which I'll come on to. The other thing is, I probably need to get out more, but I do like looking at things that people have tried to patent. I do think there is also an onus on the patent attorneys and some of the IP lawyers to not facilitate trying to protect some of these ridiculous ideas. You can see here, this is a beerbrella. Firstly, why? And secondly, you don't need to spend any money trying to protect this. If you really, really want to do it and you think you've got a market, get it to market. It's only going to be ephemeral. Yeah, you get the idea. I don't know whether you can guess what this is, but this is I've never had need of this, I don't think, but I'll move on. But you can see it's actually a urinal headrest. This is a 4-head support apparatus, and I'm not joking. This is actually a filed patent, and they've gone to the effort of actually configuring it. So again, doing the wrong thing well and spending time. If they'd have done some user testing, they'd have found that this was ridiculous and it didn't really require much more human endeavor towards it, let alone protecting it. So there is a balance on both sides here to make sure what's protected is something that there is a unique or quite unique need for that solves a real problem. So the other common barriers in innovation success, and I've highlighted the top one because actually there isn't one size fits all process. That's really important. If you say this is how you innovate, well, that depends a lot on what you're doing, the sector you're in, and also the personalities and culture of the business, particularly in smaller companies. But people don't know what should be done in a well-executed project. There's lots of barriers, of course, but obviously we can't suddenly become ersatz IP lawyers. People train for years like Hayleigh and they fully understand this. So it's really important that we bring in these people to advise us at an early stage and to guide us through the process. There's a whole load of other issues, and you will obviously know under current circumstances, too many projects, not enough resources, and lack of discipline and no leadership are also the softer sides of why things don't work. Early innovation, early stage innovation. Some of you will be at different stages of the innovation journey. So you'll get the general principle here. But this comes from the software industry, Robert Pressman. But 85% of future product costs are determined at the concept design stage. The early stage is how you're configuring the value proposition and the business model and the real value to the customers. But as you move through this journey, it becomes much more expensive to rectify problems that are solved. So early user testing, evaluation, etc., is also very important because it might give you other ideas and help you, my favorite word, pivot towards something that might be better suited to long-term sustainability of the business. And of course, if you get towards the end and you have IP infringement, that could have absolutely catastrophic effects for your business. And I've got an example at the end I'll just show you. I've got lots of examples, many of which I can't share, unfortunately, but yeah, lots of expensive mistakes being made by not thinking about IP. So I'm just referencing the Innovate UK double diamond method that's commonly used. There are some other models out there, but this is the double diamond method, and it talks largely about the early stage, the 4 key stages of discover, define, develop, and deliver as you go through the innovation journey. Obviously, there's a lot of iteration within that model. So not time today to go into too much detail on that, but I've put some logos on the left-hand side of the screen that I think are all really great resources for feeding that innovation funnel. For absolutely. So we've got resources that are often freely available from a SPASnet, PatsNav, intellectual property. You can go online and you can find out, and I do this frequently in my work, find out what else has someone done within that sort of area. I haven't got time today, but the way you search for things is also crucially important. So looking tangentially, one example might be when we looked at LED lighting, there were loads of patents around heat dissipation in LED lighting rather than the lamp itself. So again, subtle but important to feed that knowledge. Then you've got ResearchGate, and obviously being academics, we use ResearchGate a lot. There's a huge amount of papers that are published, many of them freely available, to feed that research knowledge. GfK, Mintel, Data Monitor, great sources of market data. And of course, we know BSI and EN standards, also great sources for making sure your products comply. So these are all things that are largely freely available, not the GfK and Mintel reports, obviously, but there's lots of great data out there that you can readily get hold of that feeds that broader mix to make sure you're doing the right thing. So I'll just sort of summarize a bit on IP. And I did study history of art, so it's quite nice to find out that the first first registered trademark was 1876, and this is the famous Edward Manet Bar at the Folies Bergère painting. In the bottom right, you can see the famous BAS logo, and they're the first ones that recognised the importance of it. And this is kind of, they didn't have social media or TVs in those days, so you can see the importance of branding and protecting that identity as you know, from the earliest days. The other thing is with business. Intangible assets and your business, the value of your business is much more linked to intangible assets than you might realize. For SMEs, that could be you as an individual and your brand you, as Tom Peters might call it. But you can see the trend over the years that the market value of businesses is much more associated with intangible assets. Coca-Cola, for instance, most of their value is linked to their brand, not the fizzy brown liquid, some of which is full of sugar. Not necessarily a successful product if it was launched today. So, and about half of these are protected by the various types of intellectual property. So again, the value of your business is inextricably linked to your IP. The other thing is large companies, you can see on this chart here, and we can go back to some of this, but if you look what large companies do, they do protect themselves very well in many instances, whereas SMEs tend to be slightly further behind on whether it's confidentiality agreement, trademarks, patents, etc., or design registrations. Relying on complexity of design at the bottom is something some large companies do. In other words, they get it out there, it's complex, and they iterate and they keep innovating. So there are other methods of protecting intellectual property that don't go through formal routes. But largely, small companies are less well equipped to deal with the types of IP we're talking about. So having an IP strategy, it sounds a bit management speaky, isn't it? But a plan to just think about what your return on investment could be associated with the intellectual assets that you've got. And also in that respect, to go beyond protection to consider the commercialization activities that come from it. So you might actually think that there is more value in certain tangible, protectable assets within your business than the artifact, the service, the product, etc., that you're selling. Don't worry, I'm not going to go through this list, but I put it in because actually, if you look at the reasons to protect your IP, there's hundreds. But if you think about the key ones here about market access, why protect something? You should protect something, sorry, that you've actually spent a lot of time developing, whether it's your company or brand and the R&D output. So leveraging that and protecting your inventions. Negotiations in business, we all know, is very important. So it supports the fact you might have exclusivity if it's protected. And also there might be a price premium associated with that as well, and future joint ventures. Funding, well, it is patently obvious that if you've got a protection for your business and for any intellectual asset, it could actually help you attract and impress investors and accrue more value for your business and for what you're trying to do. There are also securing loans and tax incentives associated with that. And of course, strategic value, well, the reputation and the return on investment that you might get from it, and the competitive advantage also, because if it's protected, it could be preventing other people from entering the market or entering and directly competing with you. So, and the last thing also, people do want to work for companies that have an IP culture or an R&D culture or a development culture. So again, it's important to demonstrate that when you're attracting bright young talent, particularly Brunel graduates, of course. So there is just pointing to some nice research. There's some nice information out there that's being done. This is a study by the IPO and research into design infringements. I'm an industrial designer by background. I work in the School of Design at Brunel. And we know how important design is to the British economy. Just look at the likes of Dyson and the Formula One sector and the engineering of that as well. But very few designers and design right owners actually are proactive about protecting their IP. And you can see some of the statistics on this slide here that 86% of small business said it's important, but we're unsure about what exactly is IP. And that's why we have the likes of Hayleigh and her legal profession to help demystify and prioritize where we should attack. Sounds a bit aggressive, but focus, maybe that's a better way of putting it. And there's little evidence of companies creating a holistic IP strategy integrated with what their business is doing. It should be inextricably linked to where you see your business is going. And Hayleigh's going to touch on the bottom point, but through Co-Innovate and the Brunel Legal Advice Centre at Brunel, we have been working with SMEs in London and elsewhere doing an IP audit and then linking that into a longitudinal collaboration through Brunel academics and departments and students. So, and if any of you got any interest in talking to us about that, more than happy to discuss it. And then finally, as an introduction, I do a lot of innovation sort of stuff as well. And I often will give someone some advice. I'm not indemnified, I'm not a lawyer. So I always refer to people like Hayleigh. I've met a lot of people who claim to be, but this is, I've told a couple of businesses, more than a couple actually, but that they should be thinking about IP and integrating it, and suggested that they might not invest any more money until they've had a review. Seek advice early on and act on it. Maybe people don't listen to me, but I'm in a bit of a mess and don't know what to do. You mentioned the importance of IP at your Innovation Masterclass 6 months ago. I've just had all my branding and packaging printed. Last week received a cease and desist letter. What should I do? Obviously, I gave advice that they should talk to an IP lawyer, but I could preempt this. This is, I've had about 10 SMEs send similar sort of activities. In my business, I'm very ruthless about sending out cease and desist letters, and I will do anything to protect my brand. And I have sent maybe 20 out in the course of my business to get companies to cease using our name in our sectors. So if you are using or infringing, it's really important to seek advice soon and to see, you might be able to come to some agreement, but it's important to review this and to see what you can do before you invest any further. Well, I thought I'd end on a cheery note. So thank you for your time. Any questions? We're going to do questions after Hayleigh's spoken. So I'd like to introduce now my colleague, Dr. Hayleigh Bosher from the Brunel Law School. So over to you, Hayleigh.
Hello, thanks Rob, and thanks to KTN for putting this webinar on. It's really great to connect with so many people. I'm really loving the little chat thing going on, everyone sort of networking. And yeah, I really feel like what Rob has just said is so important. Like, before we go anywhere into talking about what is IP, is recognizing that it's so important to your business. But you're all here, so I feel like you're already getting on board with the fact that it's something you should start thinking about. So thanks for coming along. So my first slide, what is IP and why should you care? I really feel like Rob already got us thinking about, there's so many important reasons. I really like that slide where you gave the list, and that's honestly just touching the surface of the benefits of IP. For me, I think the three most important reasons why you should think about IP in your business is, one, to protect whatever it is that you're creating, two, to commercialize on that, and three, to prevent issues coming later, like the infringement story that Rob mentioned. So for me, those are the three most important things from an IP perspective. When I'm talking to companies, whether that's through the Brunel Pro Bono service or through my consultancy, those are the most common things that we are talking about. So there are lots of different types of IP, and I really want to kind of reiterate what Rob said, that you don't need to be an IP expert, you don't need to be an intellectual property lawyer. That's not at all what I'm suggesting. What I want to do today, and in general this is my approach, is that knowledge is power, and if you have just enough information that you can avoid and prevent the infringements that I mentioned as one of the really important reasons, and know when it's time to go and see a lawyer, and know that it's kind of that awareness of these legal principles and these kind of things, especially the things that are there to actually help you protect your idea and commercialize and benefit from your creation. So it's just to give you an idea. We're not going to go into all the detail about all the different types of IP or even the law, really. I just want to help you understand a little bit about what types of IP are out there and which ones might be relevant to your business, and then you should really take that further, whether it's going to see a lawyer. The Pro Bono service is just one of many free legal advice centres that you could go to, or even just start with your own research on something that maybe I mentioned. So yeah, there is a Q&A, and we will have time for questions at the end. So if anything comes up that you want me to explain further, then please just drop it in the box. So the main types of IP that I'm going to explain today is copyright, trademarks, patents, designs, and trade secrets. These are probably the key 5 and the most common, most relevant to your business. Although, as I mentioned, there's a long list, so you might want to investigate further what's particularly relevant for your business. As a general rule, when you're thinking about IP, intellectual property is kind of an umbrella term that refers to lots of different ways in which you can protect your product or your service. And you should try to decompartmentalize them. So different types of IP are relevant to different aspects of your product or service or your invention, your idea. And this slide here just showing you like some examples of things that might be protected under the different types of IP. So when we think of copyright, we should be thinking of things that are written down, like a book. Also music, film, dramatic work, play, photographs, images, paintings, and your website and your social media. A trademark is traditionally the name, slogan, and logo. So basically your branding. Patents covers an invention. Design is about the appearance or shape of your product. And trade secret is, says business or financial information. So it has to be valuable information. And it might be, for example, a recipe. Rob mentioned Coca-Cola and how valuable their IP is to their business. I think they actually appear on the next slide. Their trade secret is the recipe of the Coca-Cola drink is a trade secret, and that really is the most valuable thing about their company, because if we all knew the recipe and we could all make the exact same Coca-Cola, then they wouldn't have that competitive edge. And Coca-Cola is a really good example of how they've integrated a holistic IP strategy, because they have many different types of IP in sort of their toolbox. They trademark their name, they trademark their logo, they've protected the design, shape of their bottle, and obviously, as I mentioned, the recipe is a trade secret, and they do that all over the world. So they're a really good example of how, even though I'm saying you have different types of IP that apply to different things, your product or service will probably have more than one. It's about recognizing where each thing fits within your business. So another thing, I mentioned that they do this worldwide. It's really important to know that intellectual property laws, like all laws, are territorial. So what that means is the law for copyright is different in France than it is in the UK, it's different in America, it's different in China. Your starting point is the country that you're in, but also the country that you're trading in might be, the regulation will be relevant to you. So for example, where your consumers are. And also if you are manufacturing in another country, you're going to need to look at the relevant regulations in that country as well. So I'm going to primarily be discussing UK law because that's where I am right now. But for your business, you also need to think about where your customer base is. So for example, Rob mentioned about having a European trademark registered. So if you are trading in different countries, you want to protect, you might register your trademark in all the countries that you're operating in. Okay, so I just wanted to put that there as a caveat, something to think about. So I'm going to go through the 5 different types of IP that I mentioned and just give you a little tiny introduction about what they are, and then a couple of take-home tips that I think might be useful to start thinking about relating to that type of IP. So the first one is copyright. As I mentioned, it protects things like books, music, film. Probably the most relevant to everybody right now is that it's everything on social media. So videos, photographs, and the kind of your website, things like that. It regulates your use of other people's photographs, films, because if yours is protected, so is theirs. Copyright protects, it says original expression of ideas. Now this is really important because sometimes people ask, how can I protect my idea? Well, IP, we don't really protect ideas. We protect the individual expression of that idea and how it, the idea is, like we say, it's in the public domain for everybody to use and build on. So that's good for innovation, but it's how you've individually created that, say it's a product in a way that's novel and building on the status quo, what's already there. Once you have copyright, it can last 70 years, up to 70 years after the death of the creator. So it's very long. And it gives you the exclusive right to copy. There's just some of the things that lend, perform, communicate to the public, but really it just gives you, copy is the essential word here, hence copyright, gives you the exclusive right to copy that work. So then if you wanted to, you could license that work, or you just want to prevent other people from using it, and then for example, if your website. So my copyright tips. One thing that I hear a lot is, should I post things to myself? This is called poor man's copyright. I don't know why. You could post things to yourself. You could also just email it to yourself. And what that does is it proves that that thing existed at that time. So it can be used as evidence in court to support that, but it doesn't actually show that you created that thing, because if you think about it, I could post your work to myself. It doesn't mean that it's not useful, and I have actually been part of disputes where the person had kept a record or emailed themselves, and that was used as evidence to show the thing existed at that time. My tip for you, though, is not just to simply send yourself a copy of your finished drawing of your product, for example, but to keep a detailed record of your creative process. That, in my experience, has been the most effective way to protect your and demonstrate. It's like more compelling evidence that you actually created the thing rather than just the finished product. Also, if there ever was a dispute that you copied somebody else's work and you can show where your inspiration came from and kind of explain how you came to that product or service or idea, whatever it was, then that can also be of real benefit to you. So yeah, I would recommend keeping a really good record of your creative process, not just sending yourself the finished drawing or product. Other copyright tips: be aware when you are using third-party content. So I've mentioned that everything on social media is pretty much protected by copyright, and we are often infringing other people's work by posting a picture on Instagram or Twitter. And I think it's really important to understand that that photograph might be protected by copyright, and you using it is a risk. And I have honestly had cases with clients where they're being sued for uploading a picture to their Twitter account that they didn't have permission for. I'm not trying to scare anyone and say don't do it at all, because I totally understand that that's how social media works and you want to market yourself. But the whole point is to be aware of the risks, and then you can mitigate the risk. So one thing that you can do to mitigate the risk is familiarize yourself with what we call the copyright exceptions. So that's times when you can use a copyright work without permission. Another thing that you can do is use works that are in the public domain. So the copyright has expired, or they're available through something called Creative Commons, which allows free use. Ultimately, the best thing would be to use your own original content for your social media, although that's not always possible. So again, it's just about that awareness and incorporating that into your strategy to therefore avoid risk of infringement. And the final point is actually kind of opposite, which is understanding that when you put something online, it's likely to be shared, copied, and used by other people. It's not legal, but this is what it happens. And so when you are, for example, I've worked with fashion designers who've put their designs on their Instagram, and then they've been copied before they've gone to market and been very upset about it. So I think although you have to balance that, like your Instagram account is your portfolio, but then be smart about what you post and know that it's therefore public. And although copyright is there to help you protect, sometimes the damage is already done. So my advice to that particular person for next time was something along the lines of, you could post aspects of the creative process. You could choose some items in your line that you are willing to put into the public domain and keep the very special things. So it's about having that knowledge and awareness and implementing your strategy in line with that. Okay, so just keeping an eye on the time. As I said, it's just a really brief overview as to what the different types of IP are and how IP rights are, and how you can start to think about those in your business strategy. So trademark, as I mentioned, is all about branding. Now, the point in a trademark is actually really from the consumer perspective. Can they identify who your business is, who you are, from the branding of your product or service, as opposed to your competitor? So it's about being able to distinguish goods or services. what that means is the best trademarks are the most unique, and we get a lot of clash between the marketing team and the lawyers in companies on the trademark and the branding ideas, because from a marketing perspective, especially recently, it's very cool to have minimalistic branding, but from an IP perspective, that might not be very unique. It's also quite fashionable at the minute to have a descriptive word of what your product or service is, and again, from a trademark perspective, that's not possible to register. So you need to work together if you've got different people in your business or different teams working on these aspects. They need to be working together to come up with the best branding that fits everybody's requirements, because you can't register a descriptive or common term in your industry, for example, and having the trademark is probably one of the most valuable assets of your company. Once you have a trademark, you can start licensing, sponsorship, that kind of commercialization aspect, as well as the protection. So that branding is on your product that tells the consumer they want to buy your product over the competitors. When you register a trademark, I mean, my most common issue with the trademarks that I've dealt with people through the pro bono service and my consultancy is that they didn't check the register first. So trademarks are registered. You register them in the country that you're operating in, and you register them in a class, which is another word for a category of goods or services. You can register in as many classes that you're operating in, and you pay, I've just put like guide, it's not that expensive. You can go onto the register yourself, it's pretty easy, upload your trademark and do it yourself. The problem is with that, people often go to the register and start on their way because it is pretty simple to do without seeking any advice before. So, for example, they've had their trademark rejected because it was too descriptive, or worse, they haven't checked the register before. They've developed all of their product and their branding, and then it turns out somebody else already has it registered. Trademark is a monopoly right. So once someone has registered that trademark, they own the whole thing within that class, and you can't have it. So actually, one of the pro bono clients we had last year, she had developed an entire range of products with a name. And in the pro bono, we work with the students to help advise the clients. And the students searched the register and found that there was another company with this registered trademark operating in the same field as the client. And so she was devastated because she had to rebrand all her products. Not to mention the cost of it. In a way, it was kind of lucky because they caught it before there was the cease and desist action. But at the same time, it was still a huge loss for her to go back to the drawing board. So that is why it's so important. And that's probably, if I move to the next slide, on my tips. So important to check the register first before you do anything, which again is one of those things where often IP is thought about at the end, but really for stuff like this, it's got to come at the beginning, because you don't want to have like developed all your branding strategy and then realize you can't register it, or worse, you're infringing someone else's trademark. Other tips I've mentioned that your mark must be unique and distinctive, and the more unique and distinctive it is, not the higher the protection, but the easier it is to protect, because then it's more, the consumer will be able to recognize it easier. And then if you had a competitor come along with like a similar trademark and they were trying to ride off your reputation, it would be easy for the court to see that. So if you think about some of the best or the most popular trademarks like Google, that's not a word, they made that up. So then it's very difficult for something to be similar to that without it being a clear infringement. Also with, say, Apple, even though Apple is an everyday word, it's not a word to describe anything to do with computers, and therefore it's original in that kind of displacement way. Designate with proper marks. So R in a circle is only for registered trademarks in the UK, and TM for non-registered. Again, it depends on your country, because in some countries the TM does actually mean registered. That's really confusing, I know. But just make sure that you're using the appropriate sign, because it's fraudulent to use the wrong one, even if it is just a mistake. Okay, again, just checking the time, sorry. You get, this is recorded and you will get the slides, so I won't read out all of the tips because I want to get through. So the design protects the appearance, shape, or decoration of your product. There are unregistered design and registered designs. And if you are working in product development, you should definitely look further into this, because the unregistered design gives you slightly less protection. And usually that's where we start. So you don't run away and register your design straight away, because it might not be something that's worth that investment. You might develop it and change it. But at the same time, you've got to keep your eye on it, because there is a 12-month grace period between when you have your unregistered design and your chance to register it. Because when you register it, it still needs to be technically novel. With registered design, you can renew it every 5 years and it can last up to 25 years. For unregistered design, it lasts 15 years from creation or 10 years from sale. So again, you could, if this is relevant to your business, you really need to familiarize yourself with these two options and work out how that fits within your strategy. One thing I would say about design, there are some tips here, but actually the most important one we learned from the Trunky case, which is about the registration of your design. Again, there are some things that you can do and you don't need to be a lawyer, and you don't need a lawyer, like copyright, because it rises automatically, you don't need to register it. And trademark, you could technically register, but you might need some help searching the register and making sure that your brand and your logo is appropriate beforehand. With design, again, you could technically go on and register the design yourself, but the risk is that what you register becomes the boundary of your protection. And what we learned from the Trunky case, I don't know if you know, it's the one, it's quite a famous case about a small children's suitcase shaped like an animal. And what was crucial in that case is that the type, owner of the Trunky case registered a CAD file. So it was like a grayscale drawing of the product. And essentially, he would have won the case at the end if he had instead registered a line drawing. So that's something so small and quite sad to lose the whole case over. But that's why it's so important to consult a lawyer or an expert in that area before you take the steps to do the registration, because how would you know? It's not something that you would know. It doesn't say on there, only register line drawings, because sometimes it might be more appropriate to register the CAD file. It depends on the product. So really, these other tips are important, but if you're going to remember one, that should be it. There are some exceptions. So again, this is the kind of things you want to look into if you are, if this is relevant to your business. So a patent is probably the most complicated type of IP there is, and you should absolutely, definitely seek legal advice if you think that potentially your product is patentable. And before I even tell you anything about it, the most important thing about a patent is that you can only get a patent if your idea is still novel, meaning that you have to keep it a secret. You can't disclose it to anyone. If you create something and then go and show it at a design show or pitch it even to a big company, maybe you want their investment, all that stuff, and you didn't get them to do a non-disclosure agreement, it's lost its novelty. And the threshold for novelty is really low. So there's been cases where people have taken their product out into the street to test it, and even though there was no one else in the street, they still lost the novelty of their product. So if you think that you have potentially got a patentable invention, please do seek legal advice before you do anything. That is probably the most important thing to remember about patents. Once you get a patent, they can be very valuable assets to your company. There's also needs to be a search of the register, but again, the lawyer will help you with this. And when you get one, it lasts about 20 years. Your invention has to be novel, and the threshold for the novelty in patents is much higher than the other ones. So for example, with copyright, actually two people can come up with the same idea as long as they did it independently, it's fine. With trademark, as I mentioned, you have to check the register and you can't have what anyone else has have. With patents, you have to move to the next level. You have to build on what's already there. You have to invent something new. We call it inventive step. So it's harder to get one, but they're very valuable once you have them. So if you have an invention that you think you've developed to the next step, it's got an inventive step on the status quo, the state of the art, what's already there, then you should think about seeking legal advice for a patent. Finally, trade secrets. So as I mentioned, the many soft drinks and perfumes and things like that, they base their IP protection model around trade secrets. One of the best things about a trade secret is that it lasts forever, in theory. But also you have to take steps to ensure that it stays a secret, because once it's lost forever. So that means doing things like non-disclosure agreements. In Coca-Cola and companies like that, where it's such a huge part of their value, they do things like they separate the knowledge, and actually very few people in the world know what the recipe is, and even the people working in the factories don't. They make it in different parts, and everybody is, so they separate the information. That's also how they do that with TV shows. So some people only know certain aspects of the TV format, and then nobody has the whole picture. So there's different like strategies you can put into place if you think trade secret is important for your company, and also about dealing with your employees, and it's in your employment contracts. It might be important to have a non-compete. So if you work from Coca-Cola, you can never work for Pepsi, that kind of thing. So I'm very conscious of time, and I just have 3 take-home points before I finish. 1, knowledge is power, which is kind of like my overall message of everything that I've said today, is about just at least knowing a tiny nugget of information can save your business from being sued for infringement, and also stop you making those mistakes that come and bite you later on, like making a brand and then having to change it later. Number 2, conduct an IP audit. So this is something that we do at the IP Pro Bono Centre for our clients in Brunel, but you can also do this yourself, where you look at, look at what your company is doing, think about all the different type of IP and identify where it's relevant to you. Not only your IP, but also other people's, like, are you using third-party content? What if you've got a contractor who's contributing content to your business? Who owns that? Is it in the contract? Is there a contract? All these kind of questions you need to be asking yourself. And the third thing is, once you've done your audit, then you create a holistic IP strategy. So that holistic means including all the different types of IP, but also holistic within your business. As I mentioned, things like working with the marketing department and everybody working together at IP. It should be part of your business, not a separate kind of, oh, that's for the lawyer, I don't deal with that. I think the best approach that I've seen is when people incorporate it into everything that they do. So I hope that was helpful, and sorry if I talked really fast. I was quite conscious of the time. I'm really bad for going over, but we've got just over 10 minutes where we can start looking at some of your questions.
Thanks, Hayleigh, that was fantastic, and also Robert. So I've got a few questions. One, I'm not sure you'll be able to answer, but I'm going to ask it anyway because I think it will be of interest to everybody online. Why is protecting IP so expensive?
That is an excellent question. I think, seriously, I have 2 quite serious answers, actually, even though I think the main thing about IP is that it seems like quite a foreign thing to lots of people. They're like, it's like, we don't know much about it. It's like out of space. And because it is complex and there's so many layers to it. And I think it's expensive for that reason, because the people who help you with it have trained for like a decade to get it so that we can explain it to you. So there's a lot of technical training. I mean, patent attorneys, you have no idea the amount of exams they take. They train for years. I'm not a patent attorney, but I admire patent attorneys. They're so smart, and they train in that specific field, if it's medicine or technology that they're looking at, in order to give you the best possible advice. So it's because the experts are very high level. I also think it's about return as well, because the value that the IP can offer your business, like think about Coca-Cola and how much they benefit from their IP. It's kind of, it can be the turnaround of the investment. I mean, I don't think it's all totally justified, and it is a risk. Sometimes you might register a patent that doesn't ever give you a return. But when it works, it can work really well.
Can I also because I'll give you a non-lawyer legal view on that if you like briefly. It doesn't. There's a lot of things you can do which are free. I mean, that's what I tried to emphasise when I was looking at the early stages of the funnel, because an SME can't afford to spend £30,000 here on a GfK report, can't afford a patent attorney necessarily. So there are some. Well, that's why the pro bono service partly exists at Brunel. I think we plugged that maybe enough, to be fair, Hayleigh. But other very simple things you can do, trade secrets, NDAs, non-disclosure agreements, they're pretty much free. You can download these. If you're a member of the Federation of Small Business, there's a whole load of documents you can download as well. And there's some very good networks out there. So as an SME, you want to be reducing your costs, and there's a lot of free stuff out there. There's some very nice.
Actually, it's about perception as well, because patents are very expensive, but objectively, a trademark's not that expensive. Copyright is free.
And Hayleigh, what companies must also, as well, you fully know this, but it's really important if you think you've got something that's the degree of novelty, i.e. you can do the patent search yourself. Now, I know you can do an initial search yourself. It wouldn't be the same as obviously a lawyer, but there's some, if you go on PatsNav, Aspasnet, IPO, etc., you can do a good search. And if you do think you've got something, then it's worth definitely having a chat with a professional like Hayleigh or your own patent attorney, or anyone around IP, because you might have something, but because you might otherwise disclose it publicly. You might even tweet it, and then it's you've kind of blown it in many ways. You might put it on Kickstarter, tell the whole world about what a great idea you've got, and then not have protected it in any way. So there's some very rudimentary, almost free things you can do within the IP suite of tools. If it is worth patenting, then of course you've got to think, like anything in business, about investing. And you can get R&D tax relief on some types of patents as well. And there probably are, and KTM will know this better than me, some grants out there that might support you. So this is why this is great, because the network is very important. There'll be people in this network that maybe can comment on that as well.
Thank you, Robert. There's absolutely so much important information in that. So I think you've answered a few questions anyway through all the details that you gave there. I've got one. How do you best patent AI tech, as this involves multiple mathematical calculations?
Sorry, can you say that again?
How do you best patent AI tech? It involves multiple mathematical calculations.
So if you are thinking of getting a patent, as I mentioned, you should really speak to a patent attorney who specializes in AI. There are registered AI technologies as patents, from the smallest things, blockchain, the whole range. So it's possible. It depends entirely on your product, and I'm obviously not giving any legal advice here. And actually, for patents, you should go to a specific patent attorney that specialises in that area. But it is possible to. We've even had AI inventions, like registered that the inventor is the AI, tried to be registered. So AI is a really exciting area in IP at the moment. It's very fast developing.
And you recently held a conference at Brunel, didn't you? Looking at AI. There's a lot of complex stuff in that, and a lot of screens full of 8-point font with legal clauses on them. So it is a complex area, but there might be some resource there, Hayleigh, that we could share about from that conference that you.
Yeah, well, funny enough, because it's such a developing area and the law usually lags behind the technology, there's very limited law on the AI. It's more about how we shoehorn it into the existing law, and so that's what it is possible, though, that I have seen on the register AI technologies.
How do you deal with IP in a consortium project where more than one partner is involved in an innovation?
Great question. Get this a lot. And I have to say, the main thing is about, at the very beginning, deciding who owns what, and whether it's had so many experiences where people have come and said, well, we didn't do a contract because we're friends, and then now we're not friends, and now I can't exploit whatever it is that we've made because I've fallen out with this person. So contracts is the answer. You always need to put in place who owns what. There's also a difference between if you are an employee or an employer or a contractor or a freelancer. So that all depends on the situation. Even where you have co-authors or co-creators or co-innovators, you need to decide who owns what and how that's split, especially at the beginning, because it's harder to negotiate that at the end or after you've actually created the thing of some value. I don't know if you have anything to add, Rob.
No, it just highlights a fundamental thing in all of this, actually, that if you protect something, a lot of it relies on relationships. And in many ways, I mean, one of the comments I think has been, you know, if Apple or large corporate takes your IP, what are you going to do about it? Do you have the resources to fight it? And of course, the same in collaborative projects as well. That's why Hayleigh's right. You need to get it sorted early on, because friendships break down. It's always the culture and the soft stuff that leads to failure, a lot of failure in projects. And bizarrely, as you were saying that, I'm just about to start on this particular project. And I've worked with this guy for 20 years. And as you were talking then, Hayleigh, even I was thinking, I need to get this sorted with this guy, because I've worked with him 20 years, but when business is business, and you've got to make sure it's all in place. So even if you've been in business many years and you've done this 100 times, you still can get it wrong. So if
anything, I think with friends and people you've worked with, I honestly think, maybe it's just because I'm a lawyer, but I think that the contracts make it easier because everything is set out. There's no confusion. Like, where does the risk lie? Where does the benefit lie? It's clear. It's there on this piece of paper for everybody to see. So I think it's in some ways makes the relationship easier to manage. It might be a little bit awkward at the very beginning, but especially if you're working with someone you've worked with before, it should just become completely standard that, like, right, let's get the contract done. Because I think once you get into that kind of habit of doing it that way, it just should become completely normal.
Perfect. A lot of people are asking about the pro bono service at Brunel, who it's for and how they access it.
Oh, great. Sorry, I didn't mean to like plug it so much. It was just lots of stories coming.
Yes, you did. Yeah.
Yeah. Well, it's a great service. I'm really happy to be part of it. So what I will do is I'll share the email address with you, and then maybe you can circulate it. Just drop an email to, so I don't run the pro bono service. We have someone specifically to do that, but I run the IP side of things. And what we do is we have a meeting, talk about what's going on, and we get the students to help conduct an IP audit for you, and then you can take that forward into the, my point 2, into point 3 of your strategy. Or if you have a specific question about IP that you want answered, they can do that as well. It does depend a little bit on the students in terms of a capacity. But at the minute it's open and it's running. I just mean because obviously there's nobody on campus, but we're running it remotely. So feel free to get in touch.
I'll just to clarify that for the audience, I'll get in touch with Hayleigh after this as well, and we'll circulate the best way that you can access that support, whether it's through me directly putting you in touch with the IP specialists at Brunel, or if it's going directly to them. We'll discuss that and circulate that afterwards, so it's clear for everybody. Okay. So what is the main way to commercialization of a patent or utility model? Is it a way to directly contact with a company or to use a consultancy firm? So if you want to put your patented innovations into another company, I think that is around.
I think it really depends on the market and the product. It's quite a difficult question to answer, like from an abstract point of view. Do you mean like if you want to, because you can commercialize your patent in different ways. You might be making it yourself, or you might license it. Some people just have patent portfolios and they just license that and that's their income, that's their business strategy. So there are different ways, but it would for me depend on the product and the context, the market, in how you utilize your patent.
Also, if speed to market is so crucial in the lifetime revenues in any innovation project, any development project. So if you've got something that you think is got an ephemeral lifespan, and you think speed to market might be the most critical thing, and where all your focus might go, because even if someone did copy it, you're there first, you're going to take the lifetime revenue. So making sure it's part of that balanced innovation strategy is really important, because then you can invest those revenues in developing other products, etc. So, and as Hayleigh said also, if you've got the patent, you might decide to license it rather than do all the effort yourself necessarily. So it depends on what technology or what product you've got. And some large corporates don't bother. They don't. You'll know this. Some companies don't bother patenting. They do the technology, get it to market, invest, and just keep iterating. They don't want to disclose what they're doing. They just want to saturate the market, get out, and iterate. So it's
well, exactly. That's why it needs to be holistic, your strategy, because sometimes patent's not the most effective way, especially if you want to do it fast, because patent is expensive, so you need the money, and it takes a long time, really long time, like years. If you register a trademark, you just go on, you do it, and then there is a short period of about 3 months, but it's a pretty quick process. But with patents, it can take a really long time, and it is expensive, so it's an investment. And it might be that your particular product is not even patent might not be the right strategy for you. So if you want to get quickly to market, sometimes you might use other types of IP to protect you. It depends on the product.
Can I also one really rudimentary bit of advice? Just make sure the URL in your website's available. I know it sounds like such a basic thing. There are lots of examples of people trying to register a name and not having the website available for them, or infringing on this. And it's crazy to think that such a basic thing should be done. And I'm talking about, I won't say which company actually, I'll get into trouble. It's a significant global corporation, didn't register a particular web address. And there might be someone in our
oh, you mean domain name? I was like, what's
sorry, domain name. Sorry, Hayleigh. I should.
Sorry, technical term. No, well, also that's important because now domain names and trademarks are linked. So you can't register a domain name that's also a registered trademark. They call this cyber squatting. You know, when like somebody would go and register google.com because they forgot to renew, and then try and sell it back to Google for $1 million or whatever. But that's actually illegal now. But it's really important to register your own domain name, and it has to be in correlation with your trademark, and also still have to check the trademark register that your domain name doesn't infringe someone else's trademark. Good point.
Okay, so we're running over. I'm going to ask one last question, and then I'm going to wrap up. Just to let you know, if we haven't answered your questions, I'll be sending a list of all the questions to Hayleigh and Robert afterwards, and they'll go through them, and where they can, we'll send answers back and we'll circulate them round. So one last question: how do you demonstrate that you have freedom to operate?
I don't know what it means.
Okay, well, we'll move
on. Rob, do you know what it means?
I presume that means you're not infringing someone else's IP. So freedom to operate is that there's no, you're not infringing someone else. So I'll just repeat exactly what I just said. So it needs that's the sort of thing we could pick up, I think, on the assessing freedom to operate.
If whoever wrote that question wants to clarify what they mean, because if you mean, for example, like a copyright exception, then I can explain that. But I'm not entirely sure what you mean. Sorry.
Okay, so we'll wrap up.
Last question.
We'll wrap up there, and as I said, we'll be sending questions over to Hayleigh and Robert. If you've got any last comments or questions, please do get them in now. And also, if there's any areas that you want us to provide future webinars on, please put them in the chat box now as well. My colleague Karen has just posted about it, so please do let us know what you'd like to see future webinars on. So I'm going to say thank you so much to Hayleigh and Robert for all your insightful thoughts and comments on IP, and kind of leading us through that maze as it is. If you'd like to join the Women in Innovation community, we've got an online community at World Labs. The address is there. I've already circulated the LinkedIn group if you want to go and network there as well. There is an opportunity to network on World Labs too. My email address is there if you need anything, and if you are not already signed up for our newsletter, please do sign up. That gives you first insights into any funding competitions coming up, any events that we'll be hosting, and we have got a number of other Women in Innovation events coming up in the pipeline. We are operating some coffee and networking sessions. Quite a lot of them are sold out, but keep your eye out because we are posting new ones all the time. And we've done some specific women and innovation events for specific sector areas as well, so keep your eye on them. Thank you all again for joining. Thank you Natasha for hosting the webinar, Karen so much for helping organise it, and obviously Hayleigh and Robert for the fantastic sessions that they've held for us today. And thank you all for joining. So I'm going to say goodbye, and we'll leave this up here for one more minute whilst you all sign out. Thank you.
Thank you.
Thanks, bye.